Aloha, I am John Roth, an estate planning attorney, and this is Just Ask John, where I answer your estate planning questions. We've recently discussed what is a will, what are designated beneficiary provisions. Today our question is, what is rights of survivorship? When I explained to my clients what a will is, I also explained what will substitutes are. So a will allows you to control where your assets go when you die. Will substitutes also control where your assets go, not necessarily controlled by your will. So designated beneficiary provisions and rights of survivorship are two very common will substitutes. Rights of survivorship means if you own an asset joint with another person, if one owner dies, that asset automatically becomes the surviving owner's because there is rights of survivorship. In my experience, a common scenario is where a parent will put one child on a bank account because that parent needs help writing checks, paying for monthly expenses, and so for convenience purposes has added a child on as a joint owner. Well, it's very important because if that parent wants whatever he or she owns at his or her death to go to all of the children in equal shares when she dies, then that account will not go in equal shares. If her will says, I want all of my assets to go in equal shares to my children, but that one account, which is primary asset maybe, is held joint with one child, when that parent dies, the child who has rights of survivorship automatically becomes the owner of that account. It's very important to understand how rights of survivorship, a will substitute, will control and affect your estate plan. Also, rights of survivorship is important for real estate. On your deed, if you owned real estate, your home, vacant land, a timeshare, joint with another owner, there are different ways of holding title. You can hold title tenants in common, joint tenants with rights of survivorship, and if you're married, tenants by the entirety. So tenants in common means that whether you own 1% or 99%, there is no rights of survivorship. So that means when that owner who owns whatever percentage, tenants in common, dies, their share is subject to probate and will have to go through that process to go to the beneficiaries of that person's estate. As opposed to joint tenants with rights of survivorship, where everyone owns an equal share of the property. When one owner dies, whoever is left on title automatically continue to be the owner. So if there's three, then the two own 50-50 when one person dies, and then the last survivor will own 100% of that piece of property. So no matter what your will or your trust says, when an asset has rights of survivorship, the surviving joint owner will automatically become 100% owner of that asset. So when you are putting together a will or a trust, what is very important to understand is also how you hold title to your various assets, jointly held bank accounts, jointly held real estate, because will substitutes will control those specific assets, not necessarily what your will or your trust says. So as an estate planning attorney, when I meet with my clients, I go through a list of all of their assets, not only what type of asset and how much it's worth, but how is the asset held? Is there a designated beneficiary? Are there joint owners with rights of survivorship? So hopefully this has provided you with some insight into what is rights of survivorship. I am John Roth, and this is Just Ask John. Aloha.